to all and thank you for joining us for today's webinar. I am Manpreet Kaur. Take this opportunity to welcome you all on behalf of Center for Legal Studies, Geeta Ratan International Business School on this virtual platform for interaction with Professor Dr. Naresh Kumar Vats on the topic Intellectual Property Rights with respect to Indian laws and practice. Geeta Ratan International Business School, GIBS, was established in the year 2004. GIBS is affiliated to Guru Gobind Singh Indraprastha University, Delhi. Center for Legal Studies, GIBS conducts law courses for BB LLB and BLLB approved by Bar Council of India, BCI, and management courses by All India Council for Technical Education, AICTE, Ministry of HRD, and Government of India. The institute is accredited as Category A by NAC and assessed as Category A plus by State Fee Regulatory Committee and rated highest grading A by Joint Inspection Committee of Government of NCT of Delhi and GGSIP University. The institute has been rated grade A by Academic Audit Cell of GGSIP University consecutively from past 6 years. GIBS has also been rated number 2 twice by Times B School Survey 2019 and 20. The COVID-19 pandemic is creating significant health, social, economic, and legal challenges worldwide, forcing institutes and universities to shut their physical activities. We at Center for Legal Studies, GIBS, understand that navigating the pace of change, dealing with immediate issues can only be developed through taking regular insight of the problem with the opinion of experts. The entering of knowledge-based economy and society will not be successful if we cannot create a platform of building absorptive capacity, which is a learning society, enthusiastic and ready to assimilate and apply new knowledge. To achieve the goal, suitable intellectual property right regime is necessary, enabling environment for entering knowledge-based economy and society. Conceptually, intellectual property rights or IPR is meant to provide incentives for inventors and innovation. The IPR system pursues two seemingly contradictory objectives. First, to protect the inventors from imitations and stimulate inventive activity. Secondly, to disseminate existing information and knowledge as a means to facilitate invention, activities, and innovation for the benefit of society. Even avoiding the ethical controversy regarding the boundaries of protection of intellectual property assets, it is legitimate to raise questions regarding possible welfare and economic impacts of trade-related aspects of intellectual property on developing countries today. To throw the light on the issue relating to patents as a subject of IPR, we have with us Professor Dr. Naresh Kumar Vats. Sir is currently holding post of Professor of Law and Registrar at Rajiv Gandhi National Law University, Punjab, Patiala. Prior to joining at RGNLU, Punjab, Professor Vats was working as Head of Department of Law, Founder, Chairman, CPGLS, Head Center of IPR and Proctor. Professor Vats has been teaching intellectual property laws, family law, commercial law, arbitration mechanism, cyber laws at undergraduate and postgraduate courses at Maharashtra National Law University, Nagpur, National Law University and Judicial Academy, Assam, Institute of Law, Kurukshetra University, BGC Trust University of Bangladesh, etc. He has delivered many special lectures on artificial intelligence, IPR, family law, taxation, business laws in MBA course, refresher course in Kurukshetra University, BPSMB, Kanpur Kala, NETND, Nagpur, etc. He has been working in various capacities, that is convener, admission, placement, training, discipline, IQ, ASC, etc. at Kurukshetra University as well. He was also acted as co-organizing secretary of National Seminar and Campus of Rural Lok Adalat and Legal Aid Clinic, coordinator of WIPO India Summer School 2017 between WIPO Geneva, RGNI PPM at Nagpur and MNLU Nagpur, and hosted WIPO India Summer School 2018 in the month of July 2018. Sir, we are delighted to have you here with us and request you to take the session forward. Thank you so much, sir.
Thank you. From your side, actually, the voice was echoing. I don't know from my side whether you are eligible. My voice is audible to you. Hello.
It is perfect. Your voice is perfect. You can continue.
Is it audible?
Yes, sir.
Yeah. From your side, I think it was echoing. I was not able to gather the whatever. Of course. Thank you.
Welcome, sir.
you talked of me, myself, Professor Vats, which I could not hear from your side actually. No matter. Good morning, all of you. First of all, I shall be thankful to Professor Hoti, Director of GIBS, and Dr. Anup Ghosh, and the Management Committee of GIBS providing me this opportunity. The topic is assigned to me is the intellectual property, and I had the discussion. Yes, the students from your side is probably the final years, or the students who have been taking the IP as a subject, intellectual property. And today in the present domain, the intellectual property is very important domain, because today we are in the competitive world, and in this competitive world, the major role with the economics of the intellect, that's playing very important role. Immaterial, what the geography you have, what the territory you have, or what the population you have. But if you have the intellect, certainly the people, those are having intellect, and those are making the society to exploit all the intellectual products to make it available in the market, either in the form of the patent or in the form of the copyright or the geographical indication or the trademark or the design, whatever is, whatever the facility, what we are using today. It's all because of the intellectual game only. I'll be just discussing and confining my talk on the patenting, what is the need of the patenting, and in between kind of some definitions which you will come across while discussing, and the patentable subjects or the matters, what will be essentials of the patent and how we can protect the patents. Dear friends, hope my voice is audible to all. I'll be taking the first part, how the patent started, the Paris Convention, that you as a student of law, everybody understand it. What is the role of the Paris Convention? The Paris Convention, which is mainly dealing with the industrial properties, starting from the 1886, and dealing with the intellectual property, that is industrial property. And industrial property, when we are talking of the industrial property, it is the wider sense, and the wider sense maybe including the patent one, maybe the trademark or the industrial design or the geographical indication, and blah blah, the others, the small scale industries or the utility models, or even the repression of the unfair competition. It is dealing with that. Sorry. Sir. Sir, my clock lecture chal raha hai. So we will be dealing how the Paris Convention is taking care of it, and this is protecting, promotion, and protection of the intellectual properties. And when we are talking about the Paris Convention, it is even dealing with the yes, how the Paris Convention, how the intellectual property, that should be uniform, how the property that can be taken and governed and regulated throughout the world uniformly. And for that purpose, the substantive provisions of the conventions were drawn, and the substantive provision, when we are talking of the three provisions, one is the national treatment which you are talking. And this national treatment, what we understand about the is that the convention country we are talking actually, and because the convention country, whoever so is the convention country, who are the party to it, almost the 133 countries are there for the convention country. So they have to treat every patent equally as the patent which is given the respect by their own domestic patent. As very clearly it is stating, okay, contracting state must grant the same protection to the nationals of other contracting state that it grants to the own nationals. So there will not be any discrimination between the patent which you are having as well as the patent of the other country. One part is that, the trade national treatment. Okay, you will be treating all the patent equally as your patent. And on the other hand, maybe because the convention countries or otherwise, you are a domicile of the convention country. Even if you are the different from, you are within the country. But even if you are a domicile of that particular convention country, then also you will be, your patent will be protected and that will be given the equal respect. On the other hand, the second part of the national treatment, other than the national treatment, the second part is the right of the priority. Means these are very important parts. Okay, yes, because the discrimination will be eliminated at a national and the international level. And the second part, the priority right. What is the concept of the priority right? There may be the situations when the patent is in the process or the invention is in the process, and when the invention is in the process, when you file an application for the patent. And while filing the application, sometime when you have filed the application, the inventor filed the application, and the moment the registrar of the patent may accept or may not accept because of the opposition or because of the clearance. If it is not accepted, or sometime the examination is there, and it takes a lot of time. And that purpose, by that time, if somebody come across with the somebody smell your patent or your invention, that you are likely to get it patented. So somebody is processing it, and by that time, yes, your he gets or he get influence the authorities, or somewhere he get the patent claimed. So this is the best way for protecting your patent actually. Right of the priority. Right of the priority, if you have filed an application claiming your patent, and even in the process it takes months together or years together, and unless it is examined or even finalized or notified by the Gazette notification, till then that your patent, the fiduciary relations are there between the you and the authority to whom you are filing the patent. And for that purpose, your patent is still protected. It is not in the public domain. And you will be given the right that you are the first person to bring this invention in the public domain. That is what at least the applicant, he will have the 12 months of the priority for patent and the utility models. From the date you have filed an application or the patent is notified. Similarly, as the 6 months for the design of the trademarks, the right. Suppose today you are filing an application for the patent, and your application for the patent is accepted and notified after 1 year. From the date 1 year means if somebody XYZ happen to develop your patent, so he even if he get the patent or that, so it will not be given. He will that patent will not be having that priority. Your patent will be having the priority because you are the first person to file an application. You are the first person to be notified in the Gazette of the patent. And you will have, even on the other hand, yes, when you are filing this particularly the priority right, it is for the purpose when you are filing the international applications. Because if somebody getting information or getting an idea from your patent, happen to file an application in the other country, and before you, sometime because of the speedy process, they get your patent notified. So you are there to check him, you are there to stop him. You have the right of the priority over that. On the other hand, the second part, the third part is the common rule, the principle, very subtle, the principle of the Paris Convention. The common rule that particularly says that every contracting state must follow and must legislate their own laws. And legislation of the laws, like when we are talking of the patent, means first is that patent will be independent of every country. That will be independent of every country, means there will not be any distinction, there will not be any discrimination, and because the patent depends on the countries to the country and standard, and the standard of the norms of the particular country. Your norm of standardizing your patent, laying down any criteria, that is your norm. Because your norm is differing from the norms of the United States, norms of the China, norms of the other developed country or the developing or developed countries. So your norms are different, and keeping this thing in mind, the independence of the patent will be there. Your patent is your patent, but your patent will be respected by the other country. Your patent will be respected by the convention country. Not even ignore and even say disrespect. Even if they are there is a infringement of the patent, you are liable to prosecute there for the infringement of the patent. On the other hand, like the contracting state does not oblige other contracting state to the grant of the patent, means thereby why it is independent does not mean that you have got the patent in India, and when you are applying the patent for Pakistan or China or the US, the obligation is not there to accept your patent. They are not bound to register your patent or grant you patent on particular invention, because their norms are the different. They may grant the patent, but they are not under obligation to patent. Or otherwise, even the patent cannot be refused or annulled or terminated by a contracting state on the ground, yes, your patent, you filed an application for the patent in US being a country of the convention country, and keeping in mind that it is annulled or refused to grant. On the other hand, similarly, the UK deny it because your patent is refused and annulled from America, and therefore your patent will not be accepted in UK. No, it is not, because it is independent, and the independence character is your norms are the different from the norms of the UK or from the norms of the US. On the other hand, the right to be named such as a patent, you will have your own patent in your name. You are as an inventor, the patent may not be refused, and the patent may not be invalidated on the grounds that the sale of the patented product or the patented patent product obtained by means of any patent process, means there will not be any distinction whether it is a patent or the process patent, or resulting yes, this particular product or that this particular the process product is patented from the different place. So that will not be refused for using that patent. Maybe the product patent, maybe the process patent, it is accepted as. On the other hand, each contracting state that takes legislative measures providing the grant of compulsory license. Now the other hand is how to use the patent, how to make the utility more of the patent. These are the only means, because you being as inventor is just for invention, does not the compulsion on you, you will make or you will manufacture it. You grant the license to somebody for manufacturing, or even if you can manufacture it. Even if for manufacturing, but then what is the source of the dissemination or the marketization? It is only that the agencies who can marketize your product, who can sell your product. And for that purpose, you are bound to give the license, compulsory license where the question arises, because you are probably when you are talking of your patent is not working, it is not workable. Workability is very essential for the patent, and workability means what that it is accessible to the common man. Because when we are talking of the model of the industrial application, whether in real sense the application of that particular patent is there, application for the benefit of the or for the interest of the society, for the benefit of a class of the society, and for that purpose real application is there, or real workability of the particular the patent is there. So ensuring the workability of the patent. If it is not working, then it is the agency, the government agency to grant you the compulsory for the to avoid the failure of the workability. To avoid the workability, the patent, because lot of labor you invested, lot of money you have invested on the patent, and in spite of that labor and that particular time, still it is not working. To ensuring yes, your invention must reach to the common man, must reach to every corner of the country. So for that purpose, that the compulsory license that can be even granted, but provided whether the compulsory license, before the compulsory license, the voluntary license is to be sought. If the patentee is not giving the voluntary license to person, that you are there, the government can ensuring the compulsory license, ensuring the workability of the patent, and enforcing it the compulsory. You have to grant, but for granting the compulsory, that the patentee will be deprived from the economic benefit. The purpose of the patent is the monopoly, that monopoly of sharing, monopoly of disseminating, monopoly of manufacturing, monopoly of getting the benefit of it, and that benefit will continue to be received even if the compulsory license by the government is there, or otherwise 4 years from the date of the patent application, means from the notification grant of the application within the 3 years, asking the compulsory license whether if it is workable, or otherwise the 4 years from the date of the application when the application is filed by the applicant for patent, and it must be refused by the patentee for granting the justification, granting the voluntary license, approving it and justifying, advancing your evidence. Yes, we have applied for the voluntary license, and for the voluntary license it is denied, and because the patent is not working, and to ensure the workability of the patent, seeking the application for granting the compulsory license. That's the government will take care of it. Or otherwise, even if the grant the compulsory license after the 2 year ensuring getting survey, the patent can be forfeited, because keep in mind it's of no use. Why to give unnecessary the patent there, because if the patent is not in the working condition, not giving any benefit to the society. So that is the sole purpose of it. When we are talking of the part of the philosophy or the jurisprudence of the Paris Convention was that when we are talking of the patent, the need, what is the need of the patent? Need of the patent is this must be a legal monopoly, granting the legal monopoly with the help of a particular provisions in the statute or the act. legal monopoly ke yes, you have the right or granting that, and so for the sake of just in consideration that you have to disclose in public after granting the patent. Otherwise, before granting the patent, you cannot disclose. So long as your invention remain undisclosed, it's a new. And disclosure arises okay, you have given your invention ideas and executed, and the office of the patent and the trademark office, they will notify it, and you have disclosed, you have given in the specification form. So that is the consideration of it. Okay, you will have the legal monopoly, and that monopoly fetch you the economic benefit. The patent gives the proprietors the right to prevent the others from invention in the territory which the patent applies. So that is another monopoly you will be having. Okay, you have the right to make or exploit your invention in a particular territory. That proprietor rights you will be having, because you must be even able to monitor it. You must be able to just regulate it so that your patent should not be infringed. And the patent not considered as a positive right. It's a negative right. Then you are stopping somebody to not to make or not to copy it, not to even make misuse of it. So it does not give a positive right. It gives a negative right. Negative right, you don't do it, but I will do it because I have the legal monopoly. And there may be the earlier patent, even patents are existing, but keeping that thing in mind, yes, the patents are existing, respect them, but the inventor, whoever is there, he will exploit the license of his own invention for marketing, because it is not the individual cake and individual to exploit the money from it. What is the need of the patent? Because the organizations, every organization, they are needing of the good, needing of the better one. When the competitive world, in competitive world, when we are talking, okay, rival position are there, the rival business are there. Which is the best? Are you the best, or is he the best, or am I the best? So there is a competition between you. Which product? Your product or my product? Your process or my process? Your invention or my invention? Today, if the competition, when we are talking of the, say, the mobile competition, you have the laptop or you have the Apple mobile. I have somewhere the Nokia mobile. So which is the best? Whether your configuration or my configuration, your sometime voice quality or my voice quality, or sometime the say the features of your mobile. So which one is better? And in addition to that, the better in the cost as well as the performance. So that is the need. And because when we are giving the patent of the Samsung, patent of Nokia, patent of your Apple mobile, so yes, difference is there. The quality it differ. Whether you are a private inventor or some entrepreneur or some full-time entrepreneur, immaterial it is. But you are thinking of protecting the particular organization and protecting only with the better innovation. What better innovation, what better the invention you can give, better performance you can give, better services you can give. So that is what the need of the patent. And if you are having the excellent product which is giving the best performance, definitely the people will definitely demand for your product. So that is the need of the patent. Or otherwise, when we are talking of the legal rights of the ownership it give you the legal rights in the invention. And even for the investment, because you have to marketize, and every investor will be behind you only, because if it is marketable, if it is viable, then only people will invest. It is very difficult to take out money from the pocket of the people. Unless you have your workable idea, workable patent, the people will not invest in you. Any organization, take any organization. If any of the machine, any of the product, or any of the electronic gadgets, if it is not worth for the users friendly, so people will not buy it. So that is the reason people will invest blindly, believing that yes, there is no this particular the investment will fetch you the good amount, and there is no question of it. So that is the reason people blindly closing their eyes. They are ready to invest any amount of the money in a particular say share market, or say promoting that particular organization, the particular agency. So that is the reason. And protection of your product from the time to time patent application. So if even if if you are very experienced in the electronic gadgets, maybe the laptop, maybe the mobiles, maybe different versions are there. Today you have purchased the Apple, the say 10. So tomorrow will be the 11. Sometime tomorrow will be the 11X or whatever. I don't know which product will be there. Similarly of the Samsung, means many in a series they are producing and upgrading their profile, upgrading their technology. So that is the protection. You have to remain in the competition, and remaining in a competition, the technology have to be upgraded and upgraded. So therefore, this enhancing value, it enhances the value of the business. Today, if you are investing the 1 crore rupees in a particular product, and tomorrow if you have enhanced it, you have upgraded it, sometime even if you are demanding to invest for the 2 crore or the 2000 crores, people are ready and blindly they will invest in it. So therefore, invention must be the new one. The patent, when we are talking of the patent, okay, newness and novelty character. That novelty character. In addition to the novelty character, not only that, okay, how the novel it is, means new to you, new to the public. It is not known by anybody in any of the form, either in the news or the papers or the magazines. So that novelty, that establishes, okay, it's a new. Because you have not heard of it, you have not even smelled of it. And it must involve the inventive step. Inventive step, as well as it must have the implication. How the character of the inventive step, that will be discussing. The act for this purpose, 1970 the Patent Act, it provide and protect the intellectual property, the patent particularly, and the intellectual property, when we are talking about the patent, it may be in the product form or the process form. Creation of the mind in the product form or the process form. And because the intellectual property, when we are talking of, okay, it is protecting the creation or creativity of the people. Creativity of the people, just disclosing their invention. And that is the legal monopoly when we are talking of that. Okay, it is granting the legal monopoly. And therefore, like the term, before going ahead with it, you will come across the Budapest Treaty. And this Budapest Treaty, it is dealing with the microorganism actually. Budapest Treaty, it is the international recognition of opposite microorganisms for the purpose of the patent procedure. Done in the Budapest Treaty means because like in the process patent, sometimes you have to use the microorganisms in the process. And that because when we are filing an application, even for the specification, in the specification, everything you have to write down, you have to specify. Because unless you make the examiner unable to even starting until the completion of the product or the process, he must be able to even complete within by the specification. So that specification is there, that everything what it does, it composes. So therefore the Budapest Treaty, it talks of the microorganism depositories, because different depositories are there, and for that purpose in the specification there is one clause actually. Even if when you are specifying this particular organism is the composition of a particular this process. So from where that composition is there, so you have to mention the particular depository. You have to take the consent. You have to take the. You have to even produce the evidence of that particular Budapest Treaty from the particular depository. Then only, because otherwise in air we cannot talk. So this is what the purpose of this Budapest Treaty is there. Similarly, when repeatedly I was talking of the convention country, the national treatment, while discussing the national treatment of the priority rights, the convention country, that means the country that are of the Paris Convention. Means those are in the Paris Convention, the country which is a member of that particular group, or the union of the country, or intergovernmental organization. So almost, see, we have at present the convention countries, the 133 convention countries. On the other hand, the exclusive license, when I was discussing about the license part. So exclusive license means the license from a patentee, which confer on the licensee the license and the person authorized by him, to the exclusion of all other persons, including the patentee, any right in respect of the patented invention. So you can, even as the patentee, you can give the exclusive license to stop the forfeiture of your patent, or ensuring the workability of the patent. And even whatever the exclusive license is there, even to the extent a patent is excluded there, he has the right even to marketize, he has the right even to modify it. So that is the exclusive license it is talking. On the other hand, the international application, when we are talking about the even priority right, and in the priority right, you have the that priority right is claimed when you are filing an international application. And international application, so therefore you are talking of the priority right, your domestic countries where the patent application is filed. So you will be given the priority right. And for that international application, you have the patent cooperation treaty. Means you need not to file the patent application in the different countries, but with the help of the patent PCT, which we are talking the PCT, patent cooperation treaty. So with the help of the PCT, you can file the international application. Need not to file a separate application, but the payment is to be made. But single window, which we say, it's a single window system of the international patent treaty. On the other hand, the invention, which invention we are talking? Invention, for the purpose of the patent, we are talking of the new, novelty, newness, new product, or the process involving the inventive step and the capable of industrial application. So that is the composition. Please remember, as a student of law, these are the very essential and the basic concept, that the three elements of the novelty, inventive step, and the industrial application for any patent. If either of them is missing, the patent is not a patent. Claim is not a patent. The patent is not a claim. On the other hand, when we are talking about the inventive step, what inventive step is there? A lot of dispute is there on the inventive step actually, but we'll be discussing later on. My purpose, just what inventive step is there, means an invention that involves technical advance as compared to the existing knowledge, or having economic significance, or both, and that makes the invention not obvious to the person skilled in art. Means somewhere, something, if you make some invention, some change, which is advancing from the existing, advanced from the existing. Not only to that extent, invention which is non-obvious to the common man or to the person who is skilled in a particular art. So if you are doing different from the existing, so that is what the inventive step. Not merely work so prepare, but beyond that. Beyond that, when we are talking about inventive step. On the other hand, new invention, when we are talking, new invention means the invention or the technology which has not been anticipated by publication. Means newness character, when we are talking, it should not have been anticipated by any publication in any document or used in the country or elsewhere in the world, even if you have smelled or you have seen from throughout the world, from any part of the world. So therefore, we are talking, it should be very new. Never even it is published or advertised on in any of the form or the public domain. It should not be available in the public domain, not even have fallen in the public domain. So that is the new invention we are talking. On the other hand, what silent features of the patent can be there, like in the imperial chemical industries versus controller general patent. So the essential characters of the patent is patent must be in respect of invention and not a discovery. So make a distinction between the discovery and the invention. Invention, that is the novel. Discovery, the things are existing, but you are discovering. So it is not of a discovery. We are talking of the invention. We are talking of this invention. We are talking of this invention. Sorry. In respect of the single invention, there must be a single patent. If you are inventing one invention, new one, qualifying all the criteria, so you will get only one invention, one patent. And the patent may be respect of the product or the process. That can be the patent on either product or the process also. Product, like I give you an example, yes, the composition, the mixture of you want to, yes, like a product, like a tablet or the capsule. So you are in the process of mixturing. That is the process. And the product, that is the end product which you are getting in the market. So that is the product. So patent can be on the product also or even the process also. But it is not possible to bifurcate a patent and the state that one relate to the substance and the other relate to the process. If you are the person of the product and the process, product or the process, so it's very difficult for you. You cannot do it. You cannot bifurcate the product and the process if you are the inventor. If you are the inventor of both, so you will get only the one patent, not one patent of the product, one patent of the process. In order to have a complete the patent, the specification and the claim, specification and the claim must be very clear and distinct, very clearly and very specifically defined when you are claiming as a patent. So it should be very clear. It should be very clear, and that clarity must be, yes, like as a examiner, if somebody is examining your patent, he must be able to reach to the patent. That must be very clear. What can be patented? A patent can be obtained for any invention. For an invention, the TRIPS agreement requires that a patent for whether the product or the process in all the fields of the technology, all the fields of the technology without any discrimination. It is not specifying, okay, no, this is excluded, this is included. But in the field of the technology, all the patent or the process. So that is accepted as a patent and subject to the normal test. Normal test is, that is novelty, inventiveness, and industrial application. That normal test must be qualified, otherwise the patent is not patentable. Invention for which the patent is claimed may be a product or an article or the process. In case of an article, the patent in the end product, when we are talking, remember it, okay, what I was discussing, like in the end product in the form of the tablet, means you have composed, it's a mixture of the process and what is the end process, the product, as maybe that is the mixture, or the end product maybe the tablet. So both are the independent the patent. Like the types of the patent, when we are talking, we are having the three types of the patent. One is the ordinary patent, and ordinary patent, when we are talking, okay, yes, you are simplifying filing an application and the technology or the modification, whatever the modification you are doing, whatever the newness. But on the other hand, the patent of addition, product and the process. In addition, like you have started with the patent in the process mode, and in addition, then it reaches to the product mode. So patent in addition, so that there what you will get only one patent. Okay, initially you have got the process patent, and when it is coming in the form of the product and product, so you will get only the product patent and product. So you have the opportunity either to forego the main product or the principal product, principal patent, or otherwise accept the in addition patent. And the patent of conventions. Patent of convention, it is another patent of convention when the convention countries, when the person, the applicant want to file or want to protect his own product. When you have filed patent, protecting your patent in India, and you want to protect your patent, or you want to file your application for the patent in the convention country. Means the three substantive provisions that is accepted, that is norm, but you will get another benefit of getting registered or getting patented in the product in the convention countries. So therefore, the patentable inventions must be patentable subject matters, either the process or the machine of the articles of the manufacturers or the composition of the matters, and the invention must satisfy these three criteria. The criteria: novelty, newness, or inventive step, or non-obviousness, or the usefulness, or the industrial applicability. So these are the three essentials for qualifying your patent. When we are talking of the novelty character, this novelty character is considered as the new one. Invention will cease to be novel if it has by any means been disclosed in the public, has come or the printed or in the news. So there is no novel character, either through the magazine, through the journals, or the books, or the newspaper, any of the form, if it has come, or oral discussion in workshop or the conference. So that spoils the character of the novelty. That is not the novel. Means what it clicks in the mind, non-obvious. It is never known in by any the skilled person in the art. It is not the novel. Like the Biswanath Prasad Radheshyam versus Hindustan Metal Industries, it has very clearly distinguished the invention which must be new and the useful. Novelty and the utility. It must be inventor's own discovery as opposed to the mere verification of what is already known before the date of the patent. Merely not a verification, not the discovery which is existing, but it must be the new one, qualifying the criteria of the novelty, qualifying the criteria of the industrial application, qualifying the criteria of the inventive step. So it should be very new one. It's not okay, the pre-existing, it is there and you are just verifying the data or just adding it something. No, it is not. If it is not necessary that invention should be complicated, it is not always very complex. Invention must be very complex. No, it is not. Even a simple invention that can be patented. Simple invention which is not even known by the person who is skilled in particular art. Non-obvious. Non-obvious. I give you a simple example, and that example you say, okay, like we have the many papers. So these are many papers, loose papers I have. These loose papers, and just to clip all these papers, I know I need something. Either I have the U-pin, okay, at least a U-pin design, something new, and which can clip all the papers together rather than the laying scattered. So it is not known by anybody, but it clicked in my mind, okay, yes, something must be there which can clip all the papers together. Or otherwise, like simply take as an example of these girls. They are very long hairs, but how to clip all the hairs together? The hair clip, that clip, which they can put their the hairs together. The clip, so it's a new one, very new. Or otherwise, take the all-pin. The all-pin means earlier the all-pin we were having the all-pin very small-headed actually, and nowadays with which you are getting, okay, even the head, even if you press it, it will not get any pain in your hand, but simply it will help you to at least clip the papers. Simple thing. It is not always the complex, but which is not in the minds, which is not obvious to the person. Those are in the those are skilled in the particular art. So, but provided it must have the qualification of all these the three elements of the novelty, the industrial application. So therefore, when we are talking, yes, the essential thing is that inventor was the first one who invented first to adopt it. And the principle, therefore, is that very simple invention would be an invention like even a single clip, or very simple invention, or the claim specification, like if I'm talking of, I have given you as an example, as a new invention may consist of a new integer. What new you can produce? Is it possible that 2 plus 2 is equal to 5? Is it possible as a mathematician, as a student, otherwise universally known, 2 plus 2 is equal to 4? But is it possible the 2 plus 2 is equal to 5? Mathematician, they can apply the different formula, placing their value or something like that. So they can, if they are able to prove it, 2 plus 2 is equal to 5, wonderful. Means not, it's just an example, but that is not possible. Means the purpose is composition. When we are talking of the composition of a tablet consists of, say, H2O. H2O means the composition of the hydrogen 2 and the oxygen, that is equal to the water. But somewhere, if it is possible, yes, you vary the composition of the hydrogen and the water, the oxygen. So what can be the result of it? So if you can bring something which is not obvious, yes, you can do that. Inventiveness, non-obviousness, which is the second criteria, non-obvious. What is the non-obviousness? A patent application involves an inventive step. if the proposed invention is not obvious to the person skilled in art. Prior art should not point towards the invention, implying that the practitioner could not have thought about the invention prior to the filing of patent application. Complexity or simplicity of inventive step does not have anything bearing for grant of the patent. Very simple invention can qualify for the patent if there is an inventive step between the proposed and the prior art. Mere scintilla, that is the scrap or the particles of invention, is sufficient to validate the patent. Means somewhere when we start collecting the scrap and producing something new, is it that the patent? Means it is even beyond the workshop, beyond the workshop. I give you as an example, and that example is just during the lockdown period there was a lot of hot, and during the hot sometime like you, if you simply take as an example Papa says beta do one thing, today it's very hot actually and even the flat fan is not working, so do one thing, take down the fan and clean it. And while cleaning, what you did, that you opened and unscrewed all the wings of the fan and cleaned it, proved it, placed it to the parents, and the parents says, okay, well, wonderful, you have done wonderful thing. Now you fit it better, just put it on, and what you did unknowingly, because you are not an expert in that particular area, but unfortunately or unknowingly, you fitted the wings ulta, rather than fitting it the right way, but you fitted it in ulta form actually, and placed it, switched on the fan. So what can be the consequence when you start switching on the fan and with the ulta wings? What can be the consequence? Just imagine it. Rather than giving the cool air, then what is start? You start taking off all the dust from the floor. So that can be. So it is just a non-obviousness, starting, clearing. Okay, yes, something new you started here. And with the help of this experiment, something new clicked in your mind. And ultimately what you did, okay, done. I'll do one thing. Okay, mama is while preparing the food, she's sweating a lot in the kitchen. So let me do something rather than, because you don't have the modular kitchen, but you started putting it in the fan, in the kitchen, like an exhaust fan. As an exhaust fan, or cutting the wings in on fitting it to the exhaust fan. So it will take all the warm air. Similarly, with the different note, if you are putting it in the different form, so it will give you the different result. So that is my purpose, is just giving as an idea, how the inventive steps start. Because by experimenting as well as you will get the different new things, new application of it. So that novelty character, non-obviousness, which is not even in the minds of the skilled person, those are skilled in the art. Scrapping, but something new if you are giving it, yes. 3D, section 3D, what says, yes, it protects you. Unless it is efficacious result, it is giving the new element. That is what it is protecting. And whether an alleged invention involves novelty and an inventive step is a mixed question of the law and the fact. Although no absolute test or uniformity is applicable, of course, the lot of dispute is there on this particular element, this particular non-obviousness, which may be obvious to you, may not be obvious to me. But when we are talking of the non-obviousness in the world, because does not mean it is not obvious to you and it is not obvious, it is obvious to me. But ensuring it is not known by anybody, it is not even smelled, it is not even heard, it is not even seen anywhere, then only that novelty character is there. The patent application involves the inventive step. If proposed invention is not obvious to the person skilled in the art, it should be something more than a mere workshop improvement. Merely taking it and bringing it in the workshop and just fitting it, cutting it, and making it workable does not mean the collection of the scrap. Does not mean that patent is. But what is the utility of it? It should be different. It should be efficacious. Efficacious in the price. Efficacious in its efficiency. Efficacious even to the accessibility of the person. That efficaciousness must be there. And even the complexity and the simplicity of invention that I discussed everything. It is not always the patent must be very complex. It may be a simple even. A simple invention that can be even accepted as an invention which is not even obvious. Very simple invention can qualify a patent if there is an inventive step between the proposed and the prior art. So that is accepted here. Like in the Novarti case, Union of India case, Novarti, the court held it, assistant controller held that the invention claimed by the appellant was anticipated by the prior application. So what is the new then? There is nothing new. When it was anticipated, it was by the prior publication, so it is not new. The Zimmerman patent, that the invention claimed by the appellant was obvious to the person skilled in the art. So what is the essential? It should not be obvious. It is non-obviousness. And here it says it's obvious to the person skilled in art in view of the disclosure patent, provided that the Zimmerman patent specification. The Supreme Court of India rejected the claim of the Novartis in that case. And the third element which we are going to discuss, usefulness of the industrial application. What is the utility? I tell you, yes, you did a lot. You have invested a lot of manpower, lot of lot of money. But after even investing that much labor, that much time, that much money, still your invention is not useful. Means the purpose is, it should be useful. It should have the industrial application. And the industrial application in that sense here, yes, in relation to the invention capable of industrial application, that is be used in the industry, be used in the for the utility of the people or the class of the people. It must be in possession of the utility. Otherwise, the patent is not a valid patent. It will not be considered as a valid patent. According to the patent law, industrial applicability of invention is a patentability requirement, and the general patents are granted for the invention that can be used in some kinds of the industry, somewhere, some class. Industrial applicability must be there. When we are talking, yes, it's a small toy. Pen, everybody is not using the pen. But the person, those are able to write, they only use it. Literate person does not. Illiterate person does not. Children sometimes does not. Sometimes they do write with a different pen. Officers, they do write with a different pen. Students do write with a different pen. So that is the industrial application, and that application, even generally an invention can be patentable if it possesses the factor of the novelty, it possesses the inventive step, and nevertheless the industrial application is also additional requirement for the patentability. The lack of the industrial applicability will result in the revocation of your patent. Like of course, the industrial utility requirement is the US requirement, but here we are talking about the industrial application. Section 3, specifically how I was discussing the inventive step or non-obviousness. It is discussing lot of things actually, which are not patentable, invention which are not patentable technologically, all the fields But specifically it is talking, okay, yes, the invention which is frivolous in nature and which claims anything obviously contrary to well-established natural law, which is contrary to the natural law, that is not possible to be, that cannot be patented. Invention, the primary or intended use of the commercial exploitation, for the purpose of commercial exploitation, if you start using which is contrary to the public order or the morality, or cause the serious prejudice to the human or the animals, plant life, or the health, or to the environment. So it is prohibited. It is strictly prohibited. Okay, you cannot get it patented. However, the Protection of Plant Variety Act is there. It is protecting the particularly plant breeds. But otherwise, we cannot get the patent on the plants. Like the discovery of the scientific principles, so the formulation of the abstract theory, or the discovery of the any living things or non-living things, substances occurring in the nature. So we cannot have a scientific formula for the living and the non-living things or abstract theory. Like I'm discussing, okay, yes, the known substance. 3D is discussing, okay, known substance, which does not result in the enhancement of the known efficacy. Some known substance, it is out of the patent. Known efficacy, it is out of the patent. And the substance or the mere discovery of the new property, means if you take out the mere discovery of the new property and or the new use of the known substance or the mere use of the known process, machine, apparatus, unless such known process result in the new product or the employs at least one new reactant. Let it be known substance out of the patentability, known result, known enhancement, it is out of the patent. But even if it is a known and by known process or known reactant or known composition or new discovery. So there it says, okay, even the process, machine, apparatus, unless something new, some new reactant is there, it will not be patented. Something new must be there. And something new that says, like when we are talking about the salt, ester, either combination or the other derivatives of a known substance, considered the same unless they are different. Means ester remain ester, salt remain salt, ether remain ether. But the composition, what can be the composition of these? And what result, what new reactant can be there? If you can get the new reactant by multiplying salt, sometime the 4 or ester 1 or either 2, what can be the composition? It's a testing and retesting. So there, if you get the new reactant, so yes, possibility is there, and here we are saying we are saving ourselves. Here, like the substance obtained by a mere admixture or resulting only in the aggregation of the properties of the component or thereof, or the process or the producing such substance, the mere arrangement or the rearrangement or the duplication of the known device, such as the functioning independently or any other the efficacy or the non-way. So there, even if we are talking of this part, so means the known process is there, known substance is there, and machine and the apparatus, unless we get the new reactant, and the new reactant is, okay, it has the efficacious result. Efficacious result, okay, yes, when we are talking of the composition H2O, hydrogen 2 and the oxygen 1, and the different composition of the hydrogen and the composition of the oxygen, if we have, and we can get the new result as well as new economically benefit or new accessibility. Like if the, say, giving as an example, okay, yes, if we take the paracetamol, and paracetamol, the composition of the XYZ. Say XYZ, and X into 1 and the Z into 2. And what is the composition of it? 1 into 2 only. But if we increase or decrease either of the composition, or admixture something, the third composition even, by composition, yes, one part, it give you the, say, temperature down or somewhere body yak. But if you add the third element, sometime it may also help to at least your sugar down, or sometime your BP down. So that is the new result. And on the other hand, same cost. It is accessible to the common man even. Even there is no cost, but the efficacious is, yes, it's faster than the earlier one, existing one. And the cost is also reduced. So this is the efficacy, and this is the this is how we can manipulate the third element of the industrial application. Method of agriculture, it is not patentable. Medicinal and the surgical, the process of the medicinal or the surgical curative or the psycho prophylactic or diagnostic or therapeutic treatment. So these treatment cannot be even patented. Like a medicinal, yes, like if you go in Hyderabad, there is a one treatment. Actually, the person, those are suffering from the asthma, put a baby fish in the mouth and you get treated. So that is not patented. That is not patented. So medicinal or therapeutic or surgical or the diagnostic or the any kind of the curative treatment, that is not patentable. Like even in the plant and the animals, in wool or any part of the microorganisms, like in the Dominico case, microorganisms, use of the microorganisms, but they so very safely they have saved themselves using the microorganism, because it is another part of the animals actually, because we cannot have the patent on the animals, but there they have saved it. And how they have saved it? Yes, using the microorganism, we are not killing the organisms. Organisms are kept in the frozen form, and when they are taken into the medicine, so that frozen form is no more, and they get activated to get the treatment. So they are not killing, they are using survived the living microorganisms. Even the mathematical or the business methods or computer programming or the algorithm, it is not patentable in India. But in the Germany or the European countries, there is a lot of debate, computer programming, like even the artificial intelligence. There is a lot of hue and cry is there, the programming and the algorithms must be protected. Having protected under the copyright, but not under the patenting part. Even the literary, dramatic, and the musical part. So they are protected in the copyright. The mere scheme of the rule, method, performing, mental, or the method of playing. So under the copyright, even the topography and the integrated circuit. So they are not even protected under the patent. Invention with invention, which in fact the traditional knowledge and which is an aggregation or the duplication of the known properties. Yes, very relevant here. The traditional knowledge is very relevant when we are talking about the traditional knowledge, because how we could save ourselves saving the use of the turmeric case, because the turmeric, because otherwise the turmeric case would have been out of our hands. Use of the turmeric from the very ancient time. So it is the traditional knowledge actually, but we are very poor in protecting the traditional knowledge. So therefore, that is protected under the copyright part, and at least sharing it and disseminating and printing it, the traditional knowledge. And there again the question arises, like in the novelty. If it is a novelty means it is not known. If it would have been known, or it would have been printed, or it would have been somewhere published in any of the form, the person cannot. So we are there to stop the person to have the the wrong patent in the wrong hands. If the traditional knowledge is protected and widely disseminated, widely notified, and printed in under the copyright. So that way, the traditional knowledge is not even protected under the patent, but it is protected under the copyright. No patent is granted in respect of the invention relating to the atomic energy, even the falling within the subsection 1 of the section 20 Atomic Energy Act. So that is also not protected here, because against the human or against the nature. Indian Patent Registration Act is there, which is protecting here for registration of the patent. And for the registration of the patent, simple application, filing to the controller of patent and general patent and trademark office. And who can make the patent? Who can file the patent? It is not only the inventor. Inventor, of course, obviously the first party can be their inventor. But even if the inventor is not there, even inventor do not wish to file an application for the patent, so he can authorize somebody, or you can be the person to file an application, like in the company also, in an organization while in service. So it is the organization which is filing a patent application, but not the inventor part is the different part. The applicant in whose name the application is filed, he will have the claim of the patent. True, and the first inventor. The first inventor assignees legal representative of the deceased. Otherwise, if the inventor is there and the inventor dies, so who will be the first person? The legal representative or his or her assignee person. The applicant is required to disclose all the information, name, address, nationality, and the two first inventors. The assignee can be the natural person only, and other than the legal person, such as the registered company even. So they also can be the person on behalf of, because like an organization, that is a legal person. It is not the natural person. And the research organization even, or the educational institute or the government. So they can file an application. They can be an assignee also. And wherever the inventor is not an applicant, the proof of the right to apply by way of an endorsement, who has been assigned, or the right to apply the application. So that form 1 is very essential for filing an application. Type of infringement. After the registration, there are the opportunity infringement happens of the product. And infringement is this way, yes, the product is available in the market, and when the product is available in the market in the competitive world, so we do consider direct infringement and the indirect infringement. Direct infringement, basically the patent infringement occurs when the product is substantially very close, very similar to the prior patent, sold in the market, or it is copied or marketed or used without any permission. And indirect infringement is somewhere copied. Yes, like I tell you, so give you an example, an Apple mark, your product, and Apple product, what is the mark of the Apple? What is the right way of the Apple? How to identify the mark of the Apple? I'll just let you know. The cut mark on the Apple is which is the original cut mark on the Apple is right side or the left side. So it is on the right side. Cut mark is on the right side. But if it is available in the left side, cut mark, so it is that indirect infringement. Somewhere some copies are there. So this way, the product can be even indirectly infringed. Or otherwise, literal infringement, doctrine of equivalent, means it is not you and me actually as an inventor, but it is the consumers. Consumers will understand it. Like the doctrine of equivalent, that says literal infringement, that is literally very copy, very recited, same to same almost, literally, which is existing and which is infringing. So that is the literal infringement. You can come across almost there is no cut, there is no change. There is no change. Even if no literal infringement is there, but the doctrine says, okay, it is very clearly said, okay, substantially it is establishing, okay, yes, it is the literal infringement. When a common man or the user do not identify that the product which is available in the market, or otherwise doctrine of equivalent that says the legal rule in the most of the world patent system that allow the court to hold the party liable for the patent infringement, even though the infringement device of the process does not fall within the literal scope of the patent, but nevertheless equivalent position is there. Equivalent position is there, and that equivalent position, even the prosecution of the history or estoppel, like the doctrine of prosecution of the history of estoppel, means when you have dropped or you have launched your product in the market, and you say you want to withdraw it, no, you are stopped from it because you have produced it, you have marketed it, and you have enjoyed the benefit of it, and you have deprived the economic rights of the patentee. So you are stopped and you can be asked to pay the damages. On the other hand, the prior art, who came in the market first, because after coming in the market first, that is considered as, okay, yes, you are the person to bring the product in the market. You have filed an application first, like in the priority right. So you will be having the priority over that. So thank you, dear friends. Hope yes, please. Hello.
Thank you so much, sir.
Yes, please. I'm open for the queries.
Thank you, sir, for enlightening the students with the words of wisdom. So our participants have raised many questions. I would like to acknowledge few of them. The first is, what can we do to make the patent registration process speedy?
Pardon?
What we can do to make the registration process speedy?
Yes, we have the provision. We have the provision for the PCT provision actually, and the speedy this one registration is of course the control of patent and design. They have tried their best and they have lowered the time limit for the registration and even the registration for it actually, because a lot of time is taken for the examination, even for the opposition even. So they have tried to lower it and try to minimize the time for the registration, because otherwise even comparatively to the other states, we are very slow. We were slow actually.
So the next question is, what is the impact of patented medicines on access to medicine in India?
Patented medicine and the patented medicine, like the license is also there actually, and the government is very liberal for making it workable, as well as even if as I discussed, there's sometime even kind of the essential medicines, the government is very open to grant the compulsory license and make it available and accessible to the common man for it, like even the COVID.
So the last question is, can any invention be patented after publication or display in the public exhibition?
Yes, the provision initially was actually, it was there, it was protected when the Paris Convention took it, brought it, and bring all the countries together actually, and that was the only starting point actually. Yes, because the people were, and the inventors were fearing when my publication is open, so I will not be protected. I will not be protected, and therefore keeping that thing in mind, the temporary protection is there in the protection in that way, but that is subject to the qualification of the criteria. Otherwise, temporary protection is there.
Thank you so much, sir. Thank you for enlightening and accepting our request.
Thank you. Thank you. God bless you. Stay healthy, everybody. Huh?
Thank you so much, sir.
Thank you. Thank you. Thank you. Thank you.
Thank you participants for joining. A recorded version of this webinar will be available at our YouTube channel. Thank you so much.